Hi everyone, moving forward to other sections, that is 211 and 212. 211 is related to establishment of serious fraud investigation office, and your 212 is related to investigation procedure which is taken by SFIO, that is serious fraud investigation office. So SFIO is established on 2nd of July 2003 and this is headed over by the director and few experts, and that experts are from the relevant field, that may be your banking, your corporate affair, your investigation, cyber, forensic audit, financial accounting, management accounting, cost accounting, and other law or corporate affair areas. And the director must be minimum rank of joint secretary of central government. This is all about SFIO. Now this SFIO once established, now the procedure of investigation which is taken by SFIO is like this. First of all, SFIO has to take authorization by CG for any investigation. Once take authorization, then moving forward, and SFIO director appoint a team for investigation. Once any case is handed over to SFIO, any other investigation agency can't carry out the investigation. SFIO has all the power of civil and criminal court, and he has right to issue arrest warrant against the guilt person. Fine. And every arrested person once arrested have to present it before the magistrate within 24 hours, and this 24 hour not including the traveling and the journey time. Fine. Apart from that, you must know that once SFIO make investigation, definitely that officer and their respective team make a report also. So the report is submitted to central government, and apart from that it is given to the concerned party and the companies. Reason being they also get to know about their flaws, their non-compliances and everything which is most important to follow, and they are not following it. Because of that, investigation procedure has been taken by SFIO. This is all about section 211 and 212. Fine. So moving forward, now next section is 213, 214 and 215. First of all, let's talk about 213. It is related to investigation into company affairs in other cases. Section 214 talk about the security deposits. Your 215 talk about the firm, body corporate or association not to be appointed as inspector. Fine. Let's start our section from 213 only. See, investigation is done by ROC, central government, and apart from that, few time members also demand their investigation and they want to know about the company's affair. So when and how much members, if demanded, then that procedure will be take place, is going to discuss in section 213 only. Fine. See, first point, if minimum 100 member or member having 1/10 voting power can apply to tribunal for investigation. Second, in case company does not have share capital, then 1/5 member can approach tribunal for investigation. Fine. Third, tribunal may order investigation if it is reasonably required in light of the evidences. Whatever evidence which is provided by the members, if it is sufficient enough, then definitely tribunal will give order for the investigation. Fine. Next is your security deposits. So, security deposits to be taken by central government shall be as may be specified by CG itself. So, security deposits to be taken by CG shall be as specified by CG. CG can take variable amount from different applicant, but it cannot exceed the maximum limit. And the last one is, you must remember that security deposit is for taking the procedure of investigation which is demanded by the company's members. Okay, dear, I hope that you all get to know about the things very clearly. It's 212 investigation, not by the interfere of the company. See, definitely section 212 we already discussed. Now it's 213. In 213, investigation into company affair in other cases, and the application made by not less than 100 member or member holding not less than 1/10 of total voting power in case of company having share capital. And if company is not having share capital, then in that case 1/5 of the person in the company registers of member. Fine. Once application made by any other person otherwise, just satisfy the following condition, and once the condition is satisfied, the investigation is taken place. Once investigation is taken place, the security deposit for what? For the payment of cost and expenses. This is for the payment of cost and expenses of investigation. Fine. Expenses of investigation. Here section 2 and 4 talk about that amount which is for the expenses and for the investigation purpose. Fine. Okay. Moving forward, you just remember for section 215 that investigation officer has to be individual person or a team of person. But they have their individual opinion, because a firm, a body, corporate, an association is group of person with the same opinion. So it is not, I can say that firm, body, corporate and associate is not appointed as inspector because they have their individual opinion. So we want IO must be an individual person. First thing. Second, if team of person who may have their individual opinion, there is no problem if they are a team of person, but they must have their individual opinion, then only they become the inspector for the purpose of investigation. So section 213, investigation into the company affair, minimum 100 members demand, or if it is a company with share capital, 1/10 voting power. Fine. Second, if company has no share capital, then 1/5 of the member can approach tribunal. Tribunal may give order of investigation at the light of evidences which is provided by the members. Fine. Second, it is demanded by the members, not by CG. So for this, they have to pay some security deposits for the for the meet of expenses of investigation and cost. So they have to do security deposit, which is provided by central government only, and it is definitely it is variable in nature. They are different from applicant to applicant, so there is no any fixed amount, but that must not exceed the maximum limit which is provided by the CG. Fine. Now, an inspector must be of individual capacity. Individual person must become, they must be an individual capacity of person. They have their own opinion. They never get influenced by some other person. If they have a team of person, definitely the team have their individual opinion. Fine. So this is all about section 215. And now we are moving forward to section 216, 7 and 8. Let's move. See, so section 216, 217 and 218. Section 216, section 217, section 218. Fine. What is section 216 talk about? It is related to investigation of ownership. Investigation of ownership. 217 talk about procedure and power of inspector. Procedure and power of inspector. And your 218 talk about protection of employee. Protection of employees during investigation. Protection of employee during investigation. So, our first is 216. See, generally investigation take place only in the affair, not in the structure. It means investigation in the activities in the section 210, 212 and 213 means if the company is doing something wrong, it is not the subject matter of this section. We are concerned with the distribution of ownership pattern, which may be to hide the real owner. Generally, it happens when the technical owner, as per the document, is just to hide the real owner. So, we have to find out the real ownership of the business organization. We are not talking about the guilty and the activities which is done in section 210, 212 and 213. It is just related to the subject matter of ownership and its distribution. It is all about the real owner and the hide owner. It is all about the technical owner and real owner. That's it. Nothing else is specified there. Section 210, 11 and everything is not related to this. So don't take tension. It is very important. Fine. So moving forward, see. Section 216 is basically about the ownership. So we have to think about who are or have been financially interested in the success or failure, whether real or apparent, of the company, who are or have been able to control the materiality, influence and the policy of the company, who have or had beneficial interest in share of the company. You have to determine the true person by finding out the three answers: who are and have been financially interested in success or failure, who are or have been able to control or to materially influence the policy of the company, who have or had financial interest in the share of the company or have significant beneficial owner of the company. You have to think about the three things. If the three things is related to anyone, it means that person is the true person. Fine. So let's start it. Investigation. Moving forward to investigation. First of all, in simple sense, I can say it take only places in the affair, not in the structure. Fine. Second thing, you have to remember that if the company is doing something wrong, it is not the subject matter of this section. We have to find out the real owner, and it can be happen by finding out the answer of three relevant questions, and that are three questions is you have to keep in mind first, who are or have been financially interested in the success and failure of company. Second question, who are or have been able to control or to materially influence the policy of company. The last one is who have or had been beneficial interest in shares of company. There are three questions. If you find out the answer of three questions and whosoever is the answer of all the three questions is the real owner, it means that these three questions are the important question which is help to investigate the ownership of any company in any organization. Find now procedure and power of your inspector. So see, this is the question which is asked in question examination also in 6 marks. I think in June 16 or December 16 we had to find out. I have that questions series now. I already show you. See, this is a question. See, December 16 5 marks and June 17 6 marks. Duties and power of inspector. This is most important question. You must know it. So first power is inspector can demand information and other records. Definitely they can because they are inspector. Next one is inspector can examine and definitely they can seize also. Then seizure procedures also available for them. Fine. Next one is inspector can go for definitely search and seizure. He and she can ask for anyone and anything. He can seize or detain the things. There is no one who can stop them. But the thing is that is related to investigation procedure only. Fine. Inspector can summon anyone. He has right to summon anyone. Inspector can take on the spot statement. Yes, definitely he has right to take on the spot statement of anyone while the procedure of investigation. Inspector can take help of other government authorities like police, like income tax office, like NRI tax office. He has right to ask and take help from anyone. CG can enter into agreement with foreign company and for information sharing and prosecution support. Fine. These all are the power of your inspector. Now, section 218, protection of employee during investigation. See, whenever investigation process take place, company cannot take any action against any employee. Yes, for action, they have to ask and they have to take approval of NCLT, National Company Law Tribunal. If tribunal does not respond in 30 days after the your letter of I can say your letter is sent, then within 30 days, if it is not responded by your tribunal, it is considered as auto approved, and then you can investigate any employee. There is no any foundation and restrictions. So during the course of investigation, company cannot take any action against any employee without taking approval of NCLT. And second, if tribunal does not respond, how many days? In 30 days, it considered as auto approved. Fine. This is all about section 218. Fine. Okay. I hope you guys understand. 216, just go through the topic. 216, investigation of ownership. 217, procedure and power of inspector. And 21 is related to protection of employee. Whenever investigation procedure take place, no one can take that any decision against the employee. You must ask your NCLT before that. Fine. Now, section 219 is talking about investigation into affair of related company. We all know that we have few related companies like subsidiary company, we have associate company, we have our holding company. So, now we are talking about related concern. Fine. And 220 is all about search and seizure investigation. And your 221 is freezing of asset of the company. So there are three topics. First one is 219. First one is your 219. Second one is your 220. Third one is your 221. So moving forward, 219. Investigation into affairs of related company. 220, search and seizure for investigation. Search and seizure for investigation. 221 is your freezing of asset of company. Freezing of asset of company. So we have three sections. 219, all about investigation into affair of related company. And your 220, search and seizure for investigation. And your 221, freezing of assets. So first of all, 219. If IO, investigation officer, find that it is required, it is most important, and it is required to investigate holding company. You can say, in short, holding, subsidiary and associate, HSA. Fine. As well, to find out, or you can say to proceed the investigation, then it is possible. But you have to take separate specific approval. Definitely you have to take, right? You can't do anything like this. go and check out the related companies too. So you have to take approval, shall, and that is for each and every such companies. It is not only for one company. You should take separate specific approval from each such company, for each such company. Fine. And second is, if this kind of investigation happen, report shall also be separate for each such company. Definitely, maybe there is some problem in your holding, but your subsidiaries is free of any error. So it doesn't mean that you have to create single report for all of the concerned HSAs for all the holding subsidiary and associate. No, if there is different such companies, they have their own identity. So you should make as a IO different reports also. See, if this kind of investigation happen, reports shall also be separate for each such company. Section 220, search and seizure investigation. Search and seizure we already discussed in 209 is applicable on inspection, but search and seizure under this section is applicable on investigation. So this search and seizure is only applicable on investigation. I already told you difference between inspection, inquiry and investigation. Fine. All the provisions are absolutely same except for the seizure period. We are comparing section 209 and 220. This is for your inspection, you know it very well, and this one is for investigation. So here is, you already know that under section 209 is 100 days, but there is no maximum period under this section, which means seizure will continue up to the completion of investigation. So here no maximum period under 220. Seizure will be continue up to the completion of investigation. There is no such maximum or a minimum limit. Fine. Okay, section 221 is talk about freezing of asset of company. Definitely, if there is some inspection inquiry take place and some fault company is already facing, then freezing is allowed. The freezing of assets can happen only upon the order of NCLT. See, such type of activities where some freezing, some seizure and search is important. This is not whole and sole only authority of your inspection. It means your investigating officer. You have to take the authority's approval also. That's why here the role of NCLT is also very important. And the next thing is, freezing is allowed, means period is up to 3 years. You freeze the asset of any company up to 3 years. Fine. But the most important thing is, such a freezing must be in the favor of public interest. Such freezing of asset should be in public interest. And it is order only when it is suspicious that company can dispose or destroy such asset. So in this case, an IO has right to freeze the asset of company. This is all about section 219, 220 and your section 221. Fine. 219, investigation into the affair of related company, that is your holding, subsidiary and associate. It means you have to take approval for that, and apart from that you have to make a separate report for each and every company. Search and seizure for investigation, this is only related to 220, it is investigation, and 209 is inspection. Inspection under search and seizure is different, and search and seizure under investigation is different from section 209. Here all the provisions are same except the seizing period, that is maximum 180 plus 180. Then now here only you have maximum limit, means till your investigation is not completed you have right to seize that respective document you want from anyone. Fine. Freezing of asset is related to public interest. If it is related to public interest and approval of NCLT is given, then only you can freeze it for 3 years. Fine. And once whenever it is ordered, then there is some suspicious activity and the IO has doubt that company may be disposed of or destroy the asset of the organization. That's why IO is going to seize that respective asset. Fine. Fine. Next, section 222, 223 and 224. Section 223, section 223, 224 and section 225. 223. Formalities of inspector's report. Formalities of inspector's report. 223, 224. Action after report of inspector. Action after report of inspector. Expenses of investigation. There are 3 topics we are going to discuss. So first one is your formality. See, whenever your inspector make a report, it's an interim report which is submitted to provide overall view regarding the position of company from inspector to central government. Fine. Such report is a prima facie point of view regarding the company affair, which may be genuine or objectable. A final report is also submitted at the conclusion of inspection or investigation. Each such report shall be in writing only, because we all know that writing is only a legal consent. Next, any person can take copy of such report by writing an application to central government with or without payment of fee. If investigation was performed by SFIO, the company copy of report can be demanded from SFIO only, not from central government. Fine. So, first point. And it is an interim report and it is submitted to provide overall view regarding position of company from inspector to central government. Second point, that report is a prima facie point of view regarding a company affair, which may be genuine or objectable. Fine. And final report is also submitted at the conclusion of inspection. See, you already discussed now. If inspector want, he can approve or he can say for the next second investigation also. So this is important. If it is for the interim report, if it is final, then there is a final conclusive report. Fine. That report should be in writing only, and any person can take copy of such report by writing an application to central government with or without payment. If investigation was performed by SFIO, copy of report can be demanded only from SFIO. Fine. After action. After submission of report to central government, duty of investigation IO is to end there. Now it is up to the central government what action does it take to prevent any non-compliances of law. So for I have few list of probable action which may be taken by central government. Fine. Once IO submitted the report to CG, then CG can take probable action. And they are disqualification of director, this is a point, and KMP. Maybe CG can disqualify the director or KMP, or CG can take over the company's management, or CG can give application of insolvency to NCLT, or your CG can take striking out the name of company, or CG can demand damage from wrongdoers, demand damages, or CG can recover losses from wrongdoers, awarding punishment under Companies Act 2013. These all are the probable action which has been taken by your central government once IO submitted their respective report to the central government. Now, the expenses of the investigation. First of all, you know that all the expenses of investigation shall be paid by CG itself. Shall be paid by CG itself. If nothing negative is found, if nothing negative is found in the conduct of company, such expenses cannot be recovered by CG from anyone. किसी से भी वो नहीं ले सकता है. ठीक है. Now, if prosecution take place and guilty officers are caught by investigation officer, entire expenses of means if I can say guilty person is there, then all expenses shall be paid by them. To whom? To CG. This is the procedure. Section 223 is talking about formalities of inspector report, that is an interim report. It is an interim report. If second investigation take place, then definitely the final report, which is known as the conclusive report, and any person can take that report copy by paying application fee or not. And if investigation was performed by SFIO, then you have to ask for SFIO only. Once report is submitted by IO to CGC has probable action like disqualified, the director KMP takeover, insolvency to NCLT, striking off, demand damages, recovery of losses, awarding of punishment. These all are the factors. And expenses of investigation is paid by CG only. But if there is some guilt person, definitely that such amount is definitely paid by that guilt person only. Fine. Okay, so moving forward are the next last sections, that is 2 to 6, 2 to 7, 8 and 9. See, we have 4 sections. First one is your section 2 to 6, 2 to 7, 2 to 8 and 2 to 9. This is voluntary winding up of company not to stop investigation. If such company want that if wind up the company, then investigation will be stopped. There is no such provision. Legal advisor and banker not to disclose certain information. Legal advisor and bank not to disclose certain information. 2 to 8, investigation of foreign companies. Investigation of foreign companies. And your 2 to 9 is penalty for punishment, that is for furnishing false statement, mutilation and destruction of document. Yani means any type of destruction is taken into document, then what is the penalty which is given by our respective IO, or you can say the central government. See, whenever investigation is in force and not yet completed, any winding up petition or any other attempt to close down company operation can't affect the investigation proceeding. Even if winding up petition is accepted by NCLT, wind up cannot commence without completion of investigation. This is a very simple rule. So, in short, we can say, even if winding up is accepted by NCLT, then also it can't commence without completion of investigation proceeding and action to be taken by CG. Legal advisor, there are few information which is very crucial for any company, or we can say confidential. So such confidential information is not interrogated and even not answered at the time of interrogation. Even if the answer which is resulting in litigation against the company, such answer cannot be basis of prosecution. Fine. The first point is, any legal advisor and banker to the company need not to answer interrogation which can lead to breach of confidently. Fine. Investigation of foreign company. All provisions of section 20622 are equally applicable. Section 2062229 are equally applicable on foreign company as well. Fine. Or last is, if anyone is found guilty, if anyone is found guilty of furnishing wrong information, wrong declaration, mutilation, and destroying records or attempting to do so, he shall be liable punishment under section 447. Fine. This is the end of our chapter investigation, inquiry and inspection. This chapter is very easy, and there is a very few sections, and apart from that it consists of around 5 to 6 marks. So it is very easy to score 5 to 6 marks by this chapter. Keep studying, keep focusing on your paper. December 19 is approaching day by day. You have minimum days left. So give your best, all the best for your coming examination. And if you have any doubt in this respective content, please, you can ask your query into the comment box. Fine. And now onward, the next topic will be definitely related to your winding up and mismanagement and operation. That is also an important topic, a very small topic, and consists of 4 to 5 marks. Thank you so much. Happy learning and stay tuned. Thank you so much from Anupama Shukla.